most cold, calculated, premeditated case of murder that I have ever seen.
Dried, diluted blood on the walls. There's dried, diluted blood in the tub.
After being beaten and shot several times, Seth still managed to run outside.
Two siblings convicted of murdering a boy from Ocala discovered their fate as a judge handed down their sentences. Kyle Hooper, 17, and his sister, Amber Wright, were part of a group of 5 individuals, including Charlie Ely, Justin Soto, and the ringleader, Michael Bargo. They lured Jackson to a Summerfield home on April 17, 2011, where he was beaten and shot to death. The sentencing brought emotional reactions from both families. Hooper's relatives were heartbroken, openly weeping as the judge read the sentence.
He's a follower.
Hooper's family expressed their hope for a lighter sentence, describing him as impressionable, easily influenced, and someone who has since turned to religion. They argued that his immaturity and good nature should have been considered.
After being beaten and shot several times, Seth still managed to run outside where Kyle again made a choice to continue with the plan and bring Seth back inside, knowing he would not live.
Seath Jackson's mother was adamant that the killing was no accident, insisting it was thoroughly planned. She remarked, "He's lucky we're not following the Bible and asking for an eye for an eye." Kyle Hooper apologized.
I know it may not help or bring him back in any way, but I am sorry.
The judge presiding over the case described the crime as the coldest, most calculated, premeditated murder he had ever encountered.
This case is the single most cold, calculated, premeditated case of murder that I have ever seen.
Your son has been sentenced to life.
I understand this.
Your reaction to that?
Well, it's hard. I mean, what can I say?
Kyle Hooper, 17, and his sister, Amber Wright, were both sentenced to life in prison without the possibility of parole for their involvement in the killing of Seath Jackson.
It is the judgment of the law and the sentence of the court that you spend the remainder of your natural life confined in the Florida Department of Corrections. A life sentence is imposed. You're further ordered to pay a $5,000 fine plus court costs.
She was a good girl, and she comes down here at the luring of people that shouldn't have even been in her life, get her down the wrong track and in with the wrong people, and boom, here she is. She was not mean. She is not a killer.
The other defendants, Charlie Ely and Justin Soto, received life sentences. The family of Ely blamed it on her company and claimed that she was a good girl. Michael Bargo, the ringleader, was also convicted for the murder of Jackson.
The defendant has been found guilty of murder in the first degree in a previous proceeding.
In 2013, Bargo was sentenced to death following a 10-2 jury recommendation. However, a 2016 Florida Supreme Court ruling mandated unanimous jury recommendations for death sentences, leading to a resentencing. In 2019, a new jury unanimously recommended the death penalty, which the court upheld. Bargo appealed, citing mental health issues as mitigating factors, but the Florida Supreme Court affirmed the death sentence in 2021. As of December 2024, no execution date has been set, and Bargo continues to await further legal proceedings. Sarah Boone, a 47-year-old Florida woman, was accused of intentionally causing her boyfriend's death by leaving him inside a zipped suitcase. Sarah Boone's trial began with gripping opening statements. The defense portrayed Boone as a woman acting in self-defense after enduring a history of domestic abuse, claiming her actions were not intended to harm her boyfriend, Jorge Torres Jr. On the other hand, prosecutors painted a chilling picture of the events, alleging Boone deliberately confined Torres in a suitcase during what she described as a drunken hide-and-seek game, which tragically ended in his death. Moreover, medical examinations found evidence of blunt force trauma.
We now have her new statements, which are she intentionally violently shook the suitcase, threw it upside down, hit it with a bat, hit him with a bat, committed independent forcible felonies, and that's going to be corroborated by the medical examiner's testimony to all the blunt force trauma to both sides of his face and his mouth.
The courtroom saw emotional testimony and intense arguments as the trial unfolded. Prosecutors introduced key evidence, including videos from Boone's cell phone that captured Torres pleading for help while stuck inside the suitcase. In these videos, Boone could be heard taunting him, a detail that shocked the jury. Meanwhile, Boone's defense argued she was a victim of abuse, attempting to shift the focus to her claims of being a battered partner. They also suggested Torres could have freed himself from the suitcase, challenging the idea that her actions were intentional. After weeks of arguments and testimony, the jury needed less than 2 hours to reach a verdict. Sarah Boone was found guilty of second-degree murder. The evidence, particularly the videos, played a decisive role in their decision. At her sentencing, Boone addressed the court, asking for forgiveness and standing by her claims of past abuse. Despite her plea, Circuit Judge Michael Cranick handed down a life sentence without the possibility of parole, bringing the trial to an end. Jalen Whitlock's family was left devastated after she was killed by her former partner Jalen J. Foreman during what was meant to be a joyful birthday celebration for their elder daughter. The tragic incident happened on September 12, 2024 at Whitlock's home in Northeast Houston. Foreman, 27, reportedly showed up uninvited, and what began as a tense encounter quickly escalated into a fatal confrontation.
Happy birthday, Levy. Granny loves you so much.
Whitlock's daughters witnessed the horrifying event. According to her grandmother, what should have been a day of happiness turned into an unimaginable nightmare.
The ending of it is he killed my granddaughter in front of his children, making them instant orphans.
The younger daughter often acted out what she had seen.
That's my great-grandbaby that he killed. In addition to my granddaughter, she lays down and shows you how her mother was. She will tell you my daddy my mommy. And when he shot my mommy in the head, she fell like this, and she falls. And then the was coming out of my mommy's mouth.
While the older one asked heartbreaking questions about why her mother's life ended on her birthday.
Like she wanted to have a birthday, but then she don't. Because my daddy killed my mommy on my birthday, Granny. Why on my birthday? What do I say? I just gotta let them say what they need to say.
Although Whitlock and Foreman had separated, they remained in contact to raise their daughters together. Family members described Foreman as a loving father and partner in the early years, but things changed after their relationship ended. Whitlock had since moved on, was in a new relationship, and was expecting another addition to her family.
Jalen Foreman was an excellent daddy in the beginning. He was an excellent boyfriend. Now, I'm not going to take that from him because he did that. He was an excellent father. But when the relationship changed, then all of this stuff went.
The medical examiner later confirmed she was 10 weeks pregnant at the time of her death, prompting her family to push for double homicide charges.
The mother that she is, and what we would do for that baby like we do for these babies that now we're raising, that's my great-grandbaby that he killed, in addition to my granddaughter.
After the shooting, Foreman fled the scene but turned himself in to authorities 4 days later on September 16, 2024. He was charged with murder and booked into the Harris County Jail where his bond was set at $1 million. As of late 2024, he remained in custody awaiting trial with no court date yet announced. The trial of David Tronnes, accused of killing his wife, Shanti Cooper Tronnes, shed light on the unraveling of their marriage and the events leading to her tragic death. Witnesses and evidence painted a picture of a relationship strained by disputes over expensive home renovations and Tronnes' desire to feature their house on the reality TV show Zombie House Renovations.
In this case, the manner of death is homicide, and it is almost classic for strangulation.
Testimonies revealed chilling details about the crime. The medical examiner testified that Shanti died from a combination of blunt force trauma and strangulation.
I believe that the cause of her death is a combination of the strangulation and the blunt head trauma.
Prosecutors also called a DNA expert from the Florida Department of Law Enforcement, FDLE, who testified about blood samples taken from Tronnes' clothing that matched Cooper's profile.
Were either or both of the known samples in this case present in that mixture?
Again, David Tronnes' DNA was expected to be there because they were his pants, and Shanti Cooper Tronnes is included as a possible contributor to the mixture.
To what statistical significance?
The observed mixed DNA profile is greater than 700 million times more likely.
I'm sorry, was that million or billion?
Billion.
Samantha Adams, who worked part-time as a nanny and assistant for Shanti, also took the stand. While prosecutors suggested that Shanti was hesitant about the reality TV project, Adams testified during cross-examination that Shanti had seemed excited about it.
You became aware that they were going to be involved in the zombie house flipping show? Yes, ma'am. Shanti was excited about that, wasn't she? Yes, ma'am.
Orlando Police Detective Teresa Sprague described a disturbing crime scene with diluted blood stains on the walls and bathtub, and evidence suggesting an attempt to clean up the area. Prosecutors argued that after killing his wife, Tronnes fabricated a story, claiming to have found her unresponsive in the bathtub.
The bathtub floor was dry. The tub was dry. There's dried, diluted blood on the walls. There's dried, diluted blood in the tub. The rug is pushed forward. That's not wet. The floor's not wet. The carpet's not wet.
After hearing all the evidence, the jury deliberated for 5 hours before finding David Tronnes guilty of first-degree murder. The court sentenced him to life in prison without the possibility of parole. Prosecutors described Tronnes as manipulative and calculated, pointing to his efforts to mislead investigators and hide evidence. The trial of Anthony Todt, accused of killing his wife, the family dog, 2 sons, and 1 daughter, unfolded with intense deliberations. The jury initially informed the judge that they were deadlocked, prompting instructions to continue working toward a unanimous decision.
Instruct them that any verdict that they reach must be unanimous and will not be final until published and accepted by the jury. I'll read the Allen charge and send them back for continuing deliberations.
During the trial, both sides presented their arguments. The prosecution highlighted inconsistencies in Todt's accounts, pointing to his differing statements to law enforcement and in court. They argued that the evidence clearly implicated him in the killings.
The conflict in the evidence comes from what the defendant told you yesterday. Because obviously he gave one complete statement to law enforcement and a completely different statement to you in court yesterday. The two cannot be resolved. So you're going to have to decide which version you believe.
The defense, however, suggested reasonable doubt, questioning the medical examiner's conclusions and proposing that Benadryl could have played a role in the deaths.
We have the medical examiner who can't say that strangulation or suffocation was or wasn't the cause of death. We have Dr. Goldberger who can't say that Benadryl was or wasn't a cause of death. So while we have an unnatural death, we can't even say what caused the death. So yes, the state is right. The defense is going to focus on that because that gives rise to reasonable doubt.
They even claimed that Megan, Todt's wife, was responsible, alleging a murder-suicide pact influenced by apocalyptic beliefs. In April 2022, the jury returned a guilty verdict, convicting Todt. Todt faced charges of 4 counts of first-degree murder and 1 count of animal cruelty for the tragic events that took place in their Celebration, Florida home in 2020. The court sentenced him to life imprisonment without the possibility of parole for the murders, with an additional year added for the charge of animal cruelty. The trial of Sanel Saint Simon, accused of murdering his longtime girlfriend's daughter, Alexandra Jett, brought to light a heartbreaking case. The events began in July 2014 when Alexandra was reported missing. Days later, her body was found in a wooded area near the Polk County line.
Mr. Saint Simon repeatedly said, "I did not kill my stepdaughter."
During the trial, Alexandra's mother testified through a Creole interpreter, recounting the day her daughter disappeared. She shared her growing fears and described a suspicious mark she noticed on Saint Simon's hand after Alexandra vanished.
When the defendant got in the car, did you see any injuries on him?
Yes, I saw this mark on the top of his hand and I questioned him.
Prosecutors presented evidence, including Alexandra's blood found on Saint Simon's pants and inside his apartment. Witnesses also testified about his strange behavior in the days following her disappearance. Prosecutors pursued the death penalty, arguing that Saint Simon was responsible for the tragic loss.
How is the state of Florida going to show you what I just said happened? We're going to start with the events of Monday morning, July 28th of 2014.
The defense argued Saint Simon's innocence, but the evidence and testimonies painted a damning picture of his actions. In February 2018, the jury convicted Sanel Saint Simon of first-degree murder, aggravated child abuse, and providing false information to law enforcement. 4 months later, in June 2018, he was sentenced to life in prison. For Alexandra's family, the verdict brought a sense of justice after years of grief and uncertainty. The case of Robert Roberson, a Texas death row inmate convicted of killing his daughter, Nikki Curtis, in 2002, remains deeply controversial. Roberson was sentenced to death in 2003 after prosecutors claimed he fatally shook Nikki, a diagnosis tied to shaken syndrome. From the start, Roberson insisted on his innocence, maintaining that Nikki's death was caused by complications from pneumonia, worsened by medication rather than abuse.
I can't tell you what happened to her, because I don't know.
The shaken syndrome diagnosis, once widely accepted, has faced growing skepticism in recent years. Experts now argue that other medical conditions can mimic the injuries traditionally attributed to shaking. Even the detective who initially helped convict Roberson later expressed regret, acknowledging that the case was built on flawed science.
He's a special man, and I'm ashamed that I missed that 20 years ago. We were looking for an offender, we labeled him as such, and we made it stick, all based on junk science.
In October 2024, just hours before Roberson's execution, the Texas Supreme Court granted a stay. This decision followed appeals that raised serious questions about the validity of the forensic evidence used in his trial and concerns that Roberson's undiagnosed autism might have hindered his ability to assist in his defense effectively.
What do you want to say to me? You know, me and the folks that helped put you here.
I would like to let y'all know I forgive y'all and stuff. You know, just hope and pray that we can make things right together.
The case took another turn when a bipartisan Texas House committee sought to hear Roberson's testimony, issuing a subpoena to allow his input. However, in November 2024, the Texas Supreme Court ruled that while lawmakers could request his testimony, they lacked the authority to delay his execution further. As of December 2024, no new execution date has been set, and Roberson's legal team continues to push for a review of the evidence. His defense emphasizes that modern medical understanding could reveal that Nikki's death was misinterpreted as abuse. The trial of Joseph Merlino, accused of the poisoning death of his ex-girlfriend Ellie Tran, culminated in his conviction in June 2018. Merlino was found guilty of first-degree murder after attacking Tran outside her Virginia Beach home on Valentine's Day in 2017. Prosecutors argued that Merlino injected Tran with cyanide, which led to her being declared brain dead shortly after and passing away the next day. During the initial trials, Merlino declared that he was not happy with the defense attorney and he went on hunger strike during custody.
This case is well above a generic case, okay? As you might know.
Evidence presented included surveillance footage and internet searches about cyanide, which proved pivotal in securing his conviction. Prosecutors also highlighted Merlino's alleged attempts to intimidate witnesses using encrypted messages, adding complexity to the trial. Merlino denied the charges, claiming he was not at the scene of the crime, but the jury was unconvinced.
I'm completely innocent, and the truth will come out during the trial.
During his sentencing in December 2018, Merlino appeared in court foaming at the mouth and unresponsive, delaying the proceedings. A jail doctor suggested his condition might have been stress-induced. Eventually, the jury recommended a life sentence, which the court formally imposed. Merlino is now serving a life sentence without the possibility of parole. Stephen Stearns had been charged for the alleged murder of Madeline Soto. He entered a plea of not guilty to the charges, which include first-degree murder and more than 60 additional counts involving sexual battery, lewd and lascivious acts, and possession of child abuse material.
Instead of it being on a pretrial docket, that it go onto a status docket.
Madeline Soto, the daughter of Stearns' girlfriend, was reported missing on February 26, 2020. Just days later, her body was found on March 1st in a wooded area near Hickory Tree Road in Osceola County. Authorities believe Madeline was murdered in her Kissimmee apartment. Surveillance footage allegedly showed Stearns leaving the apartment with her body and later driving to the St. Cloud area, where she was ultimately discovered.
I'd like to set the matter for October 14th, which is a Monday at 9 o'clock, please. By that date, I'll ask the parties to please coordinate with each other.
The court scheduled a hearing on October 14, 2024, after the defense asked for time, but Stearns' defense team requested additional time again to prepare for trial, citing the extensive evidence and the large number of witnesses involved. As a result, pretrial hearings have been set for September 10, 2025, with the trial expected to begin on September 22, 2025. Prosecutors have confirmed they will seek the death penalty if Stearns is convicted. Stearns remains in custody at the Osceola County Jail as preparations for the trial continue. The Florida Supreme Court upheld the 16-year prison sentence for John Goodman, a prominent polo mogul convicted of DUI manslaughter in a 2010 crash that claimed the life of 23-year-old Scott Patrick Wilson. The case stems from a tragic incident in 2010 when Goodman's vehicle ran a stop sign and collided with Scott Wilson's car, sending it into a canal where Wilson drowned. Goodman was found to have been driving under the influence at the time of the crash. Goodman appealed to overturn the decision by the 4th District Court of Appeal, arguing that the state mishandled the collection of his blood sample, which was used to determine his blood alcohol level at the time of the crash.
Just in, the Florida Supreme Court has denied the appeal for John Goodman in his DUI manslaughter conviction. Goodman was the founder of the Wellington Polo Club. He was convicted in the deadly crash of 23-year-old Scott Patrick in 2010. His attorneys had asked the court to overturn that conviction, citing the Florida Department of Law Enforcement's procedures for drawing blood were flawed and may have led to false results. Goodman's blood alcohol level was almost twice the legal limit. He is serving a 16-year prison sentence.
However, the court rejected Goodman's claim, affirming the validity of the evidence presented in his trial. Goodman was originally convicted in 2012, but a retrial in 2014 upheld the initial verdict, resulting in his 16-year sentence. Samuel Little, also known as Samuel McDowell, is considered one of America's most prolific serial killers. Now 78 years old, Little confessed to murdering nearly 100 women between 1970 and 2005, targeting marginalized and vulnerable individuals, often those involved in prostitution or struggling with addiction. Among his confessions is a claim of killing a black woman near Wichita Falls, Texas, in 1976 or 1977. Little first admitted to killing an Odessa woman in 1994, which led to further revelations about his crimes. He described disposing of the Wichita Falls victim's body outside the city, and even created a sketch of her from memory. However, despite his detailed recollection, this confession remains unmatched. Local authorities, including the Wichita Falls Police Department, Wichita County Sheriff's Office, and Texas Rangers, have yet to find a Jane Doe case that corresponds to Little's account. In total, Little confessed to 93 murders, and over 60 have been corroborated through DNA evidence and investigative work. His sketches of victims, including the Wichita Falls woman, were released by the FBI in hopes of identifying them and providing closure to their families. Despite extensive investigations by local law enforcement, including the Wichita Falls Police Department, Wichita County Sheriff's Office, and the Texas Rangers, no records have been found matching Little's description. Although authorities have considered further questioning of Little regarding the Wichita Falls case, the victim's identity remains unknown, leaving this case unresolved. Investigators urge anyone with information to contact the FBI or Texas Rangers to help shed light on the crime. In the early hours of May 9, 2019, Velvet Burns lost her life in her Jacksonville, Florida, home in a planned attack that shocked the local community. The incident was later revealed to be the result of a murder-for-hire plot orchestrated by her husband, Jerry Burns, alongside his mistress, Amanda Love. The case highlighted a web of deceit and betrayal, ultimately leading to justice for Velvet. Jerry Burns, reportedly unhappy in his marriage, collaborated with Amanda Love to carry out the plan. Their relationship, which had been ongoing for over a year, became the foundation for the conspiracy. Amanda Love involved her acquaintance, Stephen Hand, promising financial compensation for his participation in the scheme. Together, they devised the plan that led to Velvet's tragic passing. On the night of the incident, while Velvet was at home, Jerry Burns established an alibi by visiting a friend. This alibi initially diverted suspicion, but inconsistencies in his statements raised questions. Investigators uncovered critical evidence, including text messages and phone records, that tied Jerry Burns and Amanda Love to the crime. Witness testimonies and surveillance footage further implicated Stephen Hand as an accomplice, completing the chain of events.
Thank you, Your Honor. Please state your name for the record.
Amanda Love.
And you're currently incarcerated?
Yes, sir.
And what are you incarcerated for?
Second-degree murder and conspiracy to commit murder.
And who did you plead guilty to murdering?
Velvet Burns,
And who did you commit that crime with?
Jerry Burns, and Stephen Hand.
And do you see Jerry Burns here in court?
Yes.
Okay, could you say where he's seated and what he's wearing?
From here.
You can stand up if you need to.
He's on the left of his attorney in a striped shirt.
Your Honor, may the record reflect the witness's testimony.
It may so reflect.
I learned. So, Ms. Love, how did you first come to meet the defendant in this case?
Through my ex-girlfriend, Sarah McCabe.
And what was the nature of the meeting? How did y'all meet? What are the circumstances of it?
I originally met him, Sarah was using him for money. That was her sugar daddy.
And so did you end up developing that relationship?
Yes, sir, I did.
And explain to the jury how you went about that.
I was in a domestic with Stephen Hand in October 2018. We separated. After that, Sarah came to me, asked to use my cell phone to text Mr. Burns, and then we just started talking, and I started using him for money.
And what were you exchanging? What were you exchanging for that money?
Favors.
Did you pretend like you loved, liked, were interested in Mr. Burns?
Yes, sir, I did.
And were you at least marginally interested in him?
For the money.
Okay. So you never loved him?
No, sir.
Would you have married him?
For the money.
Okay. And why were you so desperate for money?
I was a single mom with 5 kids, and Stephen Hand at the time didn't have a job.
What was your drug dependency at that time?
I was on Molly, cocaine, ecstasy pills, and I was smoking weed.
And was that regularly?
Yes, sir.
Would you have considered yourself a drug addict?
Yes, sir.
Were you properly caring for your 5 children?
Yeah, it's best of my ability.
Right, but if you're drug dependent, you're not.
Yes.
Is that fair?
That's fair.
I'm not saying you don't love your children, but you weren't caring it for them like you should. Is that
No,
fair?
sir, I wasn't.
Okay. So you've pled guilty to second-degree murder and conspiracy to get second-degree murder. What was your sentence?
I got 70 years, but Judge Laws granted concurrent, so I'm doing 40 years.
Okay. So you got 40 years on the second-degree murder and 30 years on the conspiracy.
Yes, sir.
But he ran those at the same time, so you're doing 40 years.
Yes, sir.
Okay. Is that in Florida State Prison?
Yes, sir.
And has the state of Florida given you any deals?
No, sir.
Now, obviously, you committed a first-degree murder, but you pled to a second-degree murder. Is that
Yes,
true?
sir.
Were you ever indicted and charged with first-degree murder?
No, sir.
did you plead guilty to second-degree murder and conspiracy to commit second-degree murder very early in your case?
Amanda Love was arrested in June 2019, with Stephen Hand and Jerry Burns apprehended shortly thereafter. Love testified in court, admitting her involvement in the murder of Velvet Burns, a crime she committed alongside Burns and Hand. She recounted meeting Jerry through his ex-girlfriend, Sarah Emk, who was involved with him for financial support. Amanda later exploited the relationship for monetary gain, pretending to have romantic interest in Jerry, though she admitted she never loved him. At the time, Amanda was a single mother of 5, struggling with severe financial difficulties and a drug dependency, which she acknowledged affected her ability to properly care for her family. She pleaded guilty to second-degree murder and conspiracy to commit murder, receiving a 70-year sentence that runs concurrently, resulting in a 40-year term. Stephen Hand also admitted his role and received a life sentence without the possibility of parole. Jerry Burns' trial in late 2024 attracted significant public attention due to the complex and premeditated nature of the case. Prosecutors presented evidence demonstrating Jerry's involvement in organizing the plot and financing its execution. After a thorough review, the jury found him guilty of first-degree murder.
Mr. Boston or Ms. Flash, would you like the jury polled?
Yes, Your Honor.
Very well. Madam Clerk, would you please poll our jurors?
Yes, Judge. Ms. Phillips, is this your verdict?
Yes, Your Honor.
Mr. Service, is this your verdict?
Yes, Your Honor.
Ms. Brown, is this your verdict?
Yes, Your Honor.
Ms. Olumanja, is this your verdict?
Yes.
Ms. Henry, is this your verdict?
Yes, Your Honor.
Mr. Warren, is this your verdict?
Yes, Your Honor.
Mr. Lopez, is this your verdict?
Yes, Your Honor.
Ms. Posey, is this your verdict?
Yes, Your Honor.
Mr. Sheeran, is this your verdict?
Yes, Your Honor.
Ms. LaPeria, is this your verdict?
Yes, Your Honor.
And Mr. Hearing, is this your verdict?
Yes, Your Honor.
And Ms. Danowitz, is this your verdict?
Yes, Your Honor.
Thank you so much. Thank you, Madam Clerk. All right, 9:30?
Yes.
Is that sufficient? Just that
Yes, ma'am.
you can cover the rest of your docket. All right, ladies and gentlemen, having found the defendant guilty of first-degree murder as charged in the indictment, we will begin the penalty phase of this trial on Monday morning at 9:30.
Jerry's and Velvet's son and daughter also took the stand during penalty phase.
My mother, Velvet Burns, was a beautiful person, both inside and out. The hurt and the heartache that my family and I have gone through is something that I would never wish on any soul.
And now I'm planning a wedding without the guidance of my mom. And my dad won't be there to walk me down the aisle. There won't be anyone for my children called grandparents.
During the penalty phase, jurors were tasked with choosing between the death penalty, as advocated by the state, and a life sentence without the possibility of parole, as proposed by Jerry's defense. Ultimately, the jurors opted for a life sentence without parole, thereby sparing him from the death penalty. On July 8, 2023, a tragic incident occurred in Robbinsdale, Minnesota, involving a high-speed police chase that ended in a fatal collision. Officers attempted to stop 21-year-old Quinton Leon Hudson for a suspected traffic violation. Instead of pulling over, Hudson chose to flee, driving at dangerously high speeds through residential areas. The chase came to a devastating end when Hudson's vehicle collided with another car at the intersection of 36th Avenue North and Highway 100. The collision claimed the life of 34-year-old Emily Girding, a beloved special education teacher, and left her husband, John Girding, critically injured. Emily was remembered as a devoted mother, wife, and educator who made a lasting impact on her students and community. John, though seriously injured, has been focused on recovery. Hudson fled the scene on foot but was quickly apprehended. He faced multiple charges, including fleeing a peace officer resulting in death and fleeing a peace officer resulting in serious injury. The case highlighted the severe consequences of reckless behavior during police chases and sparked discussions about public safety.
First, I would like to say I am sorry for the death of Emily and the injury I caused John and the pain I caused the family. This was truly an accident. I promise you I didn't mean to harm anybody. I'm a young black male who was just scared in a moment, and I pray every day that the family can forgive me for this tragic accident. It really does hit me different. Like, teachers did help me out when I needed food and stuff like that when I was young. So it hurts me to the core that this woman is gone because of my mistake, and I have to carry that for the rest of my life. No matter what sentence I'm given, it's gonna be with me for the rest of my life, and I'm gonna try to come out a better man, and I'm gonna try to do right, fully right. So I'm just sorry. That's what I gotta say. And I hope one day you guys, the family, can one day forgive me. I'm really sorry.
In December 2024, Hudson appeared in court for sentencing. He expressed deep remorse for his actions and apologized to the family, acknowledging the pain he caused and emphasizing that the incident was unintentional. He reflected on his troubled past and vowed to use the experience to become a better person.
Mr. Hudson, if I did not previously accept your guilty pleas to count 2, you are now convicted of fleeing a peace officer in a motor vehicle, resulting in grave bodily harm. You are also adjudicated guilty on count 1, the felony charge of fleeing a peace officer in a motor vehicle, resulting in death. You are being sentenced on count 2 first. Is he demanding execution of sentence on that file?
He is, Your Honor.
Okay. You are committed to the Commissioner of Corrections for 21 months. 14 months is in custody, 1/3 on supervised release. If you violate the conditions of supervised release, you may be required to serve the entire 21 months in custody. On count 1, the sentence is concurrent, which means it's at the same time. Not one sentence and then followed by the other. You are committed to the Commissioner of Corrections for 165 months. You will serve 2/3 or 110 months in custody and 1/3 or 55 months on supervised release. If you violate the conditions of supervised release, you may be required to serve the entire 165 months in custody. Do the parties agree that there is not a conditional release term as it relates to these sentences?
Yes, Your Honor.
Towards both of these sentences, you have credit for 69 days in custody. As a result of the plea agreement you've reached, counts 3 and 4 are dismissed, and the felony charge in file 27 CR 24-4097 are also dismissed. You must provide a DNA sample. You may not use, possess, or transport firearms, ammunition, or explosives. Restitution to the victim with the initials JTG is ordered in the amount of $13,876.98, and as part of this plea agreement, restitution is also reserved for 60 days as it relates to the loss in file 24-4097. The bond you posted is discharged. Mr. Hudson, you are remanded to the custody of the Commissioner of Corrections. I hope very much that when this sentence is complete, that you are able to live a life that contributes to society and you're able to live to your full potential.
The court recognized Hudson's acceptance of responsibility and his challenging upbringing, but stressed the irreparable loss caused by his actions. The judge sentenced Hudson to 165 months, approximately 13.75 years, in prison for fleeing a peace officer resulting in a fatality, with an additional concurrent sentence of 21 months for causing serious injury. He will serve 2/3 of the sentence in custody, followed by supervised release. As part of a plea agreement, additional charges were dismissed. The court also ordered Hudson to pay restitution to the Girding family. Today, Hudson is serving his sentence while the Robbinsdale community and the Girding family continue to grieve Emily's loss and support John in his ongoing recovery. The case of Tristan Bailey, a vibrant girl from St. Johns County, Florida, captured the nation's attention due to its tragic and shocking circumstances. On May 9, 2021, Tristan was reported missing by her family after not returning home. Later that evening, her body was discovered in a wooded area near her home. Investigators determined that Tristan had been the victim of a violent act, with evidence suggesting she had tried to defend herself. The following day, Aiden Fucci, a classmate of Tristan at Patriot Oaks Academy, was arrested in connection with her death. Surveillance footage showed Tristan and Fucci walking together on the night of the incident, and Fucci was later seen carrying an item that was consistent with the evidence found at the scene. In a troubling social media post after Tristan's disappearance, Fucci posed for a selfie in a police vehicle, which further amplified public outrage.
These factors are somewhat combined. 114 wounds, 49 defensive wounds, 35 wounds to the head and neck, 29 to the back and shoulder, and 6 fatal wounds. This court has reviewed and seen more than its fair share of autopsy photos. The autopsy photos in this particular case were particularly difficult. The 49 defensive wounds indicate that Tristan Bailey was conscious, that she was aware, and that she was doing everything she could to fend off this attack. She suffered a painful, horrifying death from someone that she trusted. Her screams were most likely stifled by her own suffocating lungs. He lured her into a secluded place in the woods near his home, a person that she trusted, and he led her there under false pretenses. There was a heightened level of premeditation in this case. Based on the prior statements that he made to his girlfriend and his friend, he indicated that he was going to kill someone. At which point he determined that it was going to be Tristan Bailey, I don't know. But there was going to be a victim. He indicated that how he was going to do it, that he would take them into a wooded place, that he would stab them, he would kill them and then run away so that he could keep on killing. He told his best friend that he wanted to kill someone to see what it felt like, and he wanted to watch them bleed out. This particular crime was committed with the weapon of choice as a knife, which he nicknamed Poker. He attempted to cover it up by disposing of the murder weapon and throwing it into a lake. He then attempted to conceal evidence by hiding his shoes and shirt and jeans, taking a shower, stealthily entering his home, and then the actions immediately after with the Snapchat videos in the back of the police car and the story that he made up about pushing her and her hitting her head, which was clearly refuted by the video evidence in this case.
Initially charged as a juvenile, Fucci's case was transferred to adult court due to the severity of the crime. Prosecutors presented evidence suggesting premeditation, including concerning internet searches by Fucci in the days leading up to the incident. In 2021, a grand jury indicted Fucci on a first-degree murder charge.
Your attorney has informed me that you'd like to enter a plea of guilty to the charge of first-degree murder. That is a sentence that is a crime which is punishable by up to life in prison. The minimum sentence that the court could impose would be 40 years in prison. You just heard the state outline that range. Do you understand the range of possible penalties that you're facing if you enter this plea today?
Yes, Your Honor.
You understand that the minimum sentence that this court could impose for you would be 40 years in prison. You understand that?
Yes, Your Honor.
And the court could impose all the way up to life in prison. Do you understand that as well?
I do, Your Honor.
And the way that this works is if the court were to sentence you
to 40 years up to life. It would also be eligible for a review sentence of that sentence in 25 years. At that point, another body would then come back and review what we're doing here today, and they would look at that sentence and determine whether or not they should change that sentence. However, that's no guarantee as to what they're going to do. That's just something in the statute that requires another body to review this court sentence in 25 years. Do you understand that as well?
Yes, Your Honor.
Has anyone promised you any particular sentence that I might impose if you do this?
No, sir.
No one's said, hey, if you enter this plea today, the judge might go lighter on you or anything like that? No one's promised you anything like that, have they?
No, sir.
You understand, again, I could give you 40 years up to life in prison.
Yes, I do.
On February 6, 2023, Fucci pleaded guilty to the charge on the day jury selection for his trial was set to begin. During the hearing, he confirmed that he understood the severity of the charges, the potential penalties, ranging from a minimum of 40 years to life imprisonment, and the possibility of a sentence review after 25 years.
And Mr. Fucci just wanted to make a short statement.
I just want to say I plead out guilty, and that I'm sorry for the Bailey family and my family.
Okay.
In court, Fucci apologized to Tristan's family, expressing remorse for his actions. This plea eliminated the need for a trial and brought some measure of closure to the legal proceedings.
Having entered a plea of guilty to the crime of first-degree murder, I adjudicate you guilty of the premeditated first-degree murder of Tristan Bailey. I sentence you to life in prison. Because of your age, you are eligible for review of the sentence in 25 years. I order the Department of Corrections to notify you when you are eligible to apply for your review hearing. Madam Clerk, if you will please impose the minimum fines and court costs.
On March 24, 2023, Judge R. Lee Smith sentenced Aiden Fucci to life in prison, noting the grave nature of his actions. As Fucci was a juvenile at the time, his sentence is subject to review after 25 years, as required by Florida law. At that point, a panel will assess whether any adjustments to his sentence are appropriate. Fucci's mother, Crystal Smith, also faced legal consequences for tampering with evidence. She was seen on surveillance footage washing items of clothing that were later linked to the case. In May 2023, Smith pleaded no contest to evidence tampering and was sentenced to 30 days in jail, followed by 5 years of probation. The Bailey family, known as the Bailey 7, has worked tirelessly to honor Tristan's memory. The hashtag #, Tristan Bailey Strong, became a symbol of the community's unity and support during a difficult time. Their resilience and advocacy efforts ensure Tristan's legacy continues to inspire and bring awareness to the importance of safety and justice. Elizabeth Ann Gaskin, a 30-year-old woman from Texas, has faced legal challenges stemming from her involvement in an unauthorized use of a vehicle case. On March 1st, 2022, Gaskin was placed on deferred adjudication probation for 2 years after being charged with the unauthorized use of a vehicle. As part of her probation terms, she was required to report regularly to her supervision officer and comply with other conditions outlined by the court. However, Gaskin's compliance with these conditions was inconsistent. By November 2022, she was brought before the court for failing to report to her supervision officer. During this hearing, the judge reinforced her probation terms, adding requirements such as weekly reporting and participation in a UA hotline. Despite being given another chance to fulfill her obligations, Gaskin continued to miss her reporting duties, failing to comply for the months of May through September 2023.
Are you the same Elizabeth Ann Gaskin who was placed on deferred adjudication in 2021 CR 4146 for the offense of unauthorized use of a vehicle on March 1st, 2022 for a period of 2 years? Is that you?
Yes, ma'am.
State?
This is in the first motion to enter adjudication of guilt. Violation of condition number 4, Bexar County, Texas. The defendant, Elizabeth Ann Gaskin, who then and there failed to report to the supervision officer as directed for the months of May, June, July, August, and September 2023 in violation of condition number 4.
How do you plead to that? True or not true?
True.
It'll waive the other allegations.
Any objection to the state's waivers?
No objection, Your Honor.
The state filed a motion to adjudicate guilt and revoke Gaskin's probation, citing her repeated violations of the terms of her probation. During a court hearing in October 2024, Gaskin admitted to the allegations of non-compliance.
All right, and defense, what are you requesting?
Your Honor, we are asking for Ms. Gaskin to be given an opportunity for her probation to be transferred to Dallas. That's where she lives. Part of her problem with their failure to report was that she lived in Dallas. I know the court can see that there was a previous MTR. When she had come down here, she had kind of messed up her living situation in Dallas. She lost her phone, so she wasn't able to continue reporting. She understands, that it was on her. She could have gotten a phone and found a way to access these people and, make the calls that she needed to make. But she, like I said, her living in Dallas, she believes that being able to complete this probation there would give her an opportunity to get the help that she needs and to complete everything.
All right, is there anything you wish to say? Is there anything you wish to say?
Oh, sorry.
You want to raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand, state your name for the record.
Elizabeth Ann Gaskin.
What do you wish to say?
I would like to say that what he's saying is true, and that if we could somehow work a way for me to do my probation in Dallas, even if I have to do a Zoom video with the probation office here for it to be transferred to Dallas first, then that's fine. I'm willing to do that. I do have a phone now, and I am able to do Zoom visits for it to be transferred to Dallas, and then it'll be way easier for me to report and not violate, because I'm not trying to run. I do want to do right with my probation, and I just wish that you would give me one more chance.
She explained that her failure to report was due to unstable living conditions and challenges related to communication, such as losing access to her phone. Gaskin requested that her probation be transferred to Dallas, where she lived, and proposed using video conferencing to stay in touch with her probation officer. She requested for another chance.
Let me ask you this. Have you ever reported?
No, ma'am.
So you have been on probation since 2022, and you never reported. So are you telling the court it's taking you 2 years to get a phone? Because we're in 2024.
Yes, Your Honor, I'm aware of that, but
No. My question is, has it taken you 2 years to get a phone?
no, ma'am, but it's on. I've had a phone, but it's been on and off because it's been broken and it's been stolen from me several times. But I do have a phone now in my property, and I'm willing.
So you were here in Bexar County on a motion to revoke for the same violation that you're here now. And it was a violation of condition number 4. I denied the motion, alternate monitoring conditions to include the UA hotline until further notice and weekly reporting until further notice. So that was in November 2022. And when I gave you those rules, you still didn't report. So let me ask you this. How did you get from Bexar County to Dallas? Did you immediately, after I told you to report on November 28, 2022, when you were released, did you immediately go to Dallas?
Yes, ma'am.
How did you get to Dallas?
I had to borrow money from my dad to get a Greyhound bus to get back.
Okay, so you can borrow money from your father to get a Greyhound bus, but you can't use his phone to check in with probation?
I have no family in Dallas.
No. I didn't give you permission to go to Dallas. So my question to you is, you can borrow money from your father to get on the Greyhound bus to go to Dallas, but you can't use his phone to call probation and say, hey, I would like to go to Dallas. How old are you?
30.
So what have you done that would warrant you remaining on probation? Have you done anything?
No.
So, I mean, there's no reason for me to continue on probation, and I'm not going to continue you on probation. All right, the court is going to find you guilty
The court, however, noted that Gaskin had never reported even once during her probation period, despite being previously warned and given additional opportunities to comply. The judge expressed frustration that Gaskin had been unable to take basic steps, such as using a borrowed phone to communicate with her probation officer, while highlighting her ability to borrow money for a bus ticket to Dallas. Given her consistent noncompliance and lack of effort to meet the probation requirements, the court found her guilty of violating probation terms.
Court is going to revoke. The state is asking for, how much time are you asking for?
180 days.
Why should I give you 180 days? 180 days is the minimum. You have done nothing. The only thing you did was take someone's vehicle without their permission and go on a joyride on it, and you haven't done anything. And it's not like you're 18. So why should I give you the minimum for a case where you did absolutely nothing? That's my question for you.
I don't have an answer, ma'am.
All right. So the court is going to sentence you to 2 years in the state jail facility, give you credit for any time served. There's to be no contact with Cassandra, K-A-S-O-N-D-R-A, Gonzalez with a Z. Probation. In regards to this case, was there ever any restitution that was ordered?
Judge, I don't see any restitution.
All right, I'm showing you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it and sign it?
Yes, ma'am.
You do have a legal right to appeal, and that right to appeal is as it relates to the allegations in the motion, not the fact that you are on deferred adjudication. Do you understand?
Yes, ma'am.
This is a felony conviction. Because it's a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
On October 18th, 2024, the court sentenced Gaskin to 2 years in a state jail facility, with credit for any time served. Additionally, the judge ordered that Gaskin have no contact with the victim of the original case, Cassandra Gonzalez. She was informed of her right to appeal the decision, but this felony conviction will restrict her from owning or possessing firearms or ammunition in the future. Big thanks to our viewers for joining the courtroom journey with us. Your interest in the stories of justice is what keeps our channel alive.